Hi, I'm Nicole Slowey. I'm the Operations Director here at Qdos Contractor, and in this video today I'm going to be talking to you about some more public sector IR35 compliance activity, specifically in respect of HS2. HS2, the executive non-departmental public body, has recently issued their accounts, and within their accounts they have set aside a £9.5 million reserve in respect of a potential IR35 tax liability. Now, what we have to say at this point in time is that this is not an official tax bill. An investigation has not been concluded, but the organisation has made the decision as part of the compliance activity and internal review that's ongoing at the minute to make that reserve within their company accounts. That 9.5 million actually takes the potential liability for public sector bodies not quite getting their IR35 compliance right to over £270 million. Now let's have a look at the HS2 scenario in a little bit more detail, because there's actually some interesting facts that have come out of this one which haven't been the same as other public sector departments that we've seen subject to IR35 compliance checks. Looking at the specifics of this situation with HS2, this is somewhat different to the compliance activity that we've seen with other public sector bodies. In this case, HS2 actually have some contractors whose IR35 position had not been considered, and actually where this appears to have stemmed from is the fact that HS2 was the recipient of contracted out services by a third party supplier. In the context of IR35, we know that contracted out services is a big issue. We've seen an increase in the utilisation of contracted out services. Organisations providing consultancy or contracted out services through the periods of reform, so it's no wonder that this specific point has actually now come up as part of HMRC's IR35 compliance activity. Now, from HS2's perspective and from the perspective of that particular supplier who engaged those limited company contractors, what appears to have been missed somewhere in the supply chain is an appropriate amount of robust due diligence to establish A, is this a genuine contracted out service that's being provided, and B, as a result of that, which party is it that's ultimately responsible for considering the IR35 status of the workers, and then equally which party is then responsible from a fee payer perspective. Now, based on the provisions that exist within the legislation, if an organisation is providing wholly contracted out services to an end client, it is the party who is the supplier of those contracted out services who has the responsibility to consider the IR35 status of any workers that they engage within that service. If the third party supplier is in fact not providing wholly contracted out services and it's more akin to a resource provision, then ultimately the end client in that particular supply chain has the responsibility to consider the IR35 status of the individual worker. But as the supplier is the organisation who's contracting and paying the contractor, they remain the fee payer, and that acts in a conventional client to almost recruitment agency type structure, irrespective of the fact that that organisation may in fact consider themselves to be more akin to a consultancy organisation. Now, the responsibility for actually establishing whether a service is truly contracted out or not actually applies to both parties in the supply chain. As I said previously, we saw a significant increase in the market of organisations providing consultancy and contracted out services who perhaps had never provided those types of services before. And ultimately, we saw a lot of organisations looking for consultancy or contracted out services providers as a means to essentially manage their risk in some cases, or potentially circumvent having any responsibility from an IR35 perspective. Now, as Qdos, the point that we have always maintained is that both organisations in the supply chain should seek to establish their own due diligence on that particular arrangement that exists between the third-party consultancy supplier and the end client organisation, but that ultimately both organisations should come together and agree in writing as to how they actually see that relationship, the nature of the work that's being provided, and equally communicate which party is going to undertake the IR35 determinations, carry the IR35 responsibilities as part of that engagement, and more importantly, ensure that that party is in turn actually fulfilling their IR35 obligations by establishing and undertaking status assessments as part of their ongoing fulfilment of that particular contract. What we don't know at this point in time is the level of engagement that the third party supplier has actually had in this ongoing review that's been happening with HS2. And equally, we don't know if HS2 or in fact HMRC will look to exercise any other aspects of the legislation in terms of, okay, are we actually concretely sure of whether this is a contracted out service or not, being the first part, and then understanding from there, for example, if it is a legitimate contracted out service, did the third party supplier exercise their IR35 obligations? So it's one definitely for us to watch to see if we see more information come to light over the coming months. But it just reinforces that point that organisations who are either providing contracted out services or the recipients of contracted out services, and where there are contractors in those supply chains, the organisations need to ensure that they take appropriate amounts of due diligence, document that due diligence, and engage with each other as client and supplier to ensure that it is crystal clear as to, based on the work that you have undertaken, which party is responsible for the IR35 determination piece in respect of the contractors in the supply chain, and clarity of what that IR35 determination process ultimately is going to be. To stay up to date with Qdos news and videos, please subscribe to our channel.